Good morning, and welcome to the webinar event, Hacking and Privacy in the 21st Century, hosted by Pactera. Pactera is a leading IT service provider focused on solutions. With over 23,000 employees in over 17 global locations, Pactera is focused on growing Fortune 500 companies with strategic consulting, customized software development, data science and analytics, and digital brand management. Visit us on the web at www.pactera.com. Our first speaker today is Mr. Joseph Hester. As Senior Corporate Counsel and Consultant, Mr. Hester holds expertise in information technology and data privacy and security with a focus on cloud platforms and websites. He specializes in the resolution of critical legal, business, and operational issues for cloud services, including public, private, and hybrid cloud solutions. His knowledge base covers a wide variety of areas, such as EU data protection, safe harbor, privacy shield, EU model clauses, and binding corporate rules.
So that's the goal of my presentation. I'll spend about 25 minutes or so going through that, and I'll be leaving 5 minutes or so at the end to answer questions you may have. I hope you can see this chart that I have here. It talks about GDPR being the most important change in data privacy regulations in 20 years. If you really think about this, the existing general data privacy directive was put in place in 1995, and so that was even before the internet was in regular use, and so the world at that time is very, very different from the world today. In fact, the amount of data that was collected in the course of a year in 1999, we collect more data today in one day than we collected in a whole year in 1999. So the explosion in data, in the different devices, the way we use data has changed so dramatically over the past 20 years. One thing you'll note in this chart here is there's a real focus on European laws, and it mentions that the first European law is in 1970 and then refers to other European laws, and then the safe harbor in 2002. Well, one thing I want to remind folks is that the United States also has been active in the privacy area. In fact, it enacted the first privacy law back in 1970 called the U.S. Fair Credit Reporting Act, and that protected credit information of individuals. And so during this time, there's been a lot of work within the United States on various laws. In fact, that Fair Credit Reporting Act was updated in 2003. I think we're all familiar with the Health Insurance Portability and Accountability Act that was enacted in 1996, and the Children's Privacy and Protection Act was enacted in 1998. For those of you in the financial service business, you'd be familiar with the Gramm-Leach-Bliley Act in 1999. If you look at it from the public sector point of view, one of the first acts was the Freedom of Information Act, or the FOIA Act, and that was back in 1966. In 1974, there was the Privacy Act, which established the fair information practices to be used by government. So a lot of times when the Europeans look at the U.S. approach to data protection, they often don't really understand the sectorial approach that we take. And in fact, in many cases, we do have substantial data privacy protection laws on our books. The next slide talks about the complexity of the legislation. So one of the first pieces of legislation was back in 1990. The second, which is the current one, is the DPD, dates back to 1995. The new GDPR, which is really effective in 2018, May 2018, is substantially bigger than these prior laws. So the complexity continues to increase with time. Uh, for those of you who have businesses in Europe, I'm sure your day-to-day life has been impacted significantly by the Max Schrems decision this past October. Max Schrems is a PhD student, and folklore has it that he was in the Bay Area and had attended some Facebook meeting or conference where they were talking about data privacy and data security. And I think he became very concerned about what he heard at that conference, and he went back to Europe. He's an Austrian, and he filed more than like 25 to 30 complaints with various data processing authorities, and for the most part, the Austrian and German data processing authorities basically refused his complaints. He was able to get a hearing from the Irish data processing authority, and they also refused his complaint. Then the high courts in Ireland referred the complaint to the Court of Justice of the European Union. And much to the surprise of everyone, this court invalidated the safe harbor provision. The safe harbor provision was a mechanism put in place by the U.S. Commerce Department in cooperation with the EU that allowed for the safe transfer of personal data of Europeans to the United States. And as a result of that, many multinational companies no longer had a valid way or legal way of transferring personal data from Europe to the United States, whether that be employee data or customer data. So this event this past October significantly changed the regulatory environment because one of the key means for people complying with the European data laws was invalidated by this decision. I wanted to start, before we go into detail on the GDPR and some of its differences, I wanted just to provide a little bit of a foundation just briefly to those who may not really work in the privacy area day to day. It's interesting to note that privacy itself is not an explicit right in the U.S. Constitution. It is referred to in the Bill of Rights and in several amendments to the Bill of Rights. One of the first articulation in modern times of the right to privacy goes back to more than 100 years ago by Samuel Warren and Louis Brandeis. And interestingly enough, it was technology back then that caused them to raise this concern. They were out for a stroll after dinner, and some photographers from one of the newspapers took pictures of them. And they really felt that that was an invasion of their privacy, and they wrote this seminal article on the right to privacy, and that's back then more than 100 years ago. Since then, there's been a handful of Supreme Court cases on privacy, and as I mentioned previously, there are a number of U.S. laws that were published, that were enacted in the 60s, 70s, 80s, and 90s to protect privacy. It's important when we look at the European regulations that we have a common set of terms in terms of what we're talking about. Personal information is a key term. In the EU, that's referred to as personal data. In the US, we may use the term personally identifiable information. Canada uses personal information. In addition to personal information, there's non-personal information, and that's data that's not really identified or identifiable to a given subject. Within personal information, there's also special categories of data that is viewed as sensitive information. For example, health information, social security numbers, and the like. Here is the actual definition in the GDPR of personal data. And so you'll see that they go to great lengths to describe it in a greater level of clarity than in the past. And this is important because this defines, this defines what data would in fact be subject to these regulations. So this is a key definition. I wanted to touch briefly on the sources of information, because when you really look at whether or not you have obligations with regard to personal information, first you have to determine, is it personal information in accordance with the definitions provided for above, but then you also have to look at, well, where is the source of that personal information? If that personal information is publicly available or is from public records, then frequently a lot of these rules and regulations do not apply to it. The rules and regulations really apply to non-public personal information. That's information that is not publicly available. In the U.S., the approach to personal information and big data is very different from the European Union. In the European Union, they look at privacy rights similar to the way that Americans look at the Second Amendment and the right to guns in the United States. Privacy rights are important around the world, but in particular in Europe, they take on special significance. So within the context of the U.S., there's a real emphasis on industries involved with big data, and more or less big data is encouraged and is seen as an opportunity for innovation and growth. Whereas in Europe, they take the exact opposite approach, that automated processing of data is verboten, meaning that it's not permitted unless expressly granted by these regulations. So they take a very different approach. Some other key terms that we'll touch upon as we go is the data processor, data controller, and the data subjects. Simply put, the data controller is the person, is typically the business who first collects the data from the customers. The data processor would be somebody hired by the data controller to process that information on behalf of the data controller. The data subjects are the individuals whose information has been obtained by the data controller. Another principle that we'll touch upon is fair information practices, and those really speak to notice and awareness of the data that's being collected, choice and consent for the data subjects, access to and participation by the data subjects, integrity and security, and in enforcement and redress. So the fair information principles are really designed to help protect the data subjects from abuse by the data controllers and the data processors. In terms of models of privacy protection, in the EU they take a comprehensive approach. So the existing one is that 1995 data directive that is still in place, but will be replaced by the GDPR in 659 days and 7 hours. There are other countries that take a co-regulatory approach, and that's Canada, Australia, and New Zealand. And so, in essence, you have different trade groups and associations along with the government engaged in how do they better manage and handle information, whether that be medical information, financial information, and the like. The Japan and the U.S., they take more of a sectorial approach. So as I discussed before, within the U.S., we have a HIPAA to address health information. We have Child Online Privacy Protection Act to address information of minors. We have FERPA to address student records, and then there's a number of laws that address financial records, such as Gramm-Leach-Bliley. There's also, in addition to these actual laws, there's a number of self-regulatory industry-driven processes, such as the payment card industry data security standard. So the EU Data Protection Directive, that was established in 1995, and basically the way it worked is, as it relates to the transfer of data, it allowed for the transfer of personal data of EU residents outside of the EU to countries that provide an adequate level of protection. In the countries that were deemed to provide an adequate level of protection, some examples are Argentina, Canada, Iceland, and so on. If you were not a country where it was deemed that you provided an adequate level of protection, you had four options. The first option was that you entered into model contract clauses. And so if you were the data controller, you had model contract clauses with any processors or any of your affiliates with regard to the transfer of that data from Europe to the United States. The second was binding corporate rules, and binding corporate rules are rules that are put together by an enterprise that set forth how they're going to protect the personal data of EU residents sent outside of the EU. And those rules need to be reviewed and approved by the data processing authority in order for them to be effective. The third approach was the U.S. Department of Commerce Safe Harbor program. And that was the program that was invalidated this past October through the Schrems decision. Now, just last month in July, the EU and the Commerce Department did agree upon a replacement to the Safe Harbor program, and that program is called the Privacy Shield. So companies today who had previously relied on the Safe Harbor program, they can look to the Privacy Shield to comply. Both the Safe Harbor program, which is no longer valid, and the privacy programs are self-certifying programs. But the Privacy Shield program provides more teeth and more redress by data subjects than the previous Safe Harbor program. A fourth way to transfer data outside of that, outside of the EU, is to get the unambiguous consent of the data subjects. So if you're in a country like the United States, then these are the four options you have with complying with the EU data laws as they apply today. That will change under the GDPR in May of 2018, and we'll be talking about that in a minute. The actual GDPR document itself, it's different from the directive because it is in fact a law, it's a regulation. The 1995 directive required the EU member countries to enact legislation in order to make the 95 law effective. This new law, the GDPR, is effective and applicable to all countries in May of 2018. There's no separate legislation. At the same time, there's probably up to 50 places in the GDPR where it refers to the fact that member states may add higher levels of protection or different levels of protections subject to their own requirements in that particular country. It's interesting to note there are 127 pages of this regulation. The first 59 pages are recitals. There's 107 recitals, and there's 64 articles. Many of the recitals are very helpful in terms of better explaining their intent on how they want to manage this process. What I'm going to do now in the next 10 slides is go over a document prepared by the International Association of Privacy Professionals, and it highlighted the 10 top operational impacts of GDPR. My focus will be really more from a legal perspective if I was counseling you as a client as to what you needed to keep in mind in order for you and your business to comply with GDPR. So here's the top 10 differences. The first one is data security and data breach notification. The good news is that the GDPR actually provides for a lot more specific guidance around what does it mean what does data security mean. It also opens the door for demonstrating compliance through approved codes of conducts and approved certification systems. And I think over the next 2 years and after the law is implemented, I think we'll see a lot of work in that area because that's going to be the best way to implement this legislation on a scalable in a scalable manner. It's not possible for the regulators to review each and every company, and so they're going to rely more and more on these codes of conducts and certifications. And these codes of conducts and certifications really provide an opportunity for you in putting together your compliance program. So if you want to definitively determine whether or not you meet the data security requirements, you can use one of these programs. The next is they did focus on the data breach notification requirements. In the U.S., this is really determined at a state level, and there's more than 50 there's 50 state laws concerning data breach. And so a lot of people get concerned because there are differences between the state laws. So what GDPR tried to do was to harmonize the approach in the EU. So they more or less stipulated what were the rules around what is a data breach and what's the timing for the data breach. So in one sense that's helpful, but in another sense perhaps some of the requirements are too stringent. Next is that the GDPR for the first time requires that you hire a data protection officer. Today in Germany, you may need to hire a data protection officer, but in general, it's not required in the EU. And so if you are a business that meets these requirements, then you're required to hire a data protection officer. You could outsource that activity to a law firm or a consulting firm. There are specific rules around how that employee is managed and the independence of that employee and the ability of that employee to get the necessary resources. The next area that they go into greater detail is the subject of consent. They are a lot more specific around consent, especially as it relates to special categories of data. It requires explicit consent for special categories of data. At the same time, it does allow for regular consent to be provided through a statement of clear affirmative action. In terms of cross-border data transfers, the BCRs, the binding corporate rules, those will still remain in effect. Standard contractual clauses will also remain in effect. They will no longer require the data protection authority's approval, but it's likely that they will be updated and require further tuning. There's a new Article 42 that allows for transfers based on certifications. And then there will be hefty fines, as we'll get to in a minute. I also wanted to point out that there is the ability to transfer data subject to these specific rules. So if it's needed to protect the vital interest of a data subject or if it meets one of these other requirements. So there are exceptions to these rules, and you should be familiar with these exceptions to these rules. Another important area is profiling, a lot stricter requirements around profiling. For the purposes of this legislation, profiling is not really intended to apply to direct marketing. It's really intended to apply when business decisions are being made based on that. So like if you were applying for a job or if you were applying for credit, there's much more stringent requirements and explicit consent is required. Plus, at the objection of the data subject, they could stop the profiling and get their data back. Okay. I'm running behind a little bit. Let me just see if I can finish this up in the next three minutes or so. So number 6, another important concept is the right to be forgotten, and this is a result of the Google Spanish case, where where basically processors are required to delete data under certain circumstances. And not only is the processor required to delete the data that it has, but it needs to use reasonable efforts to delete the data that other processors that may have as well. So that's a real important concept, and it's something that you need to build into your engineering and marketing processes so that you're able to comply with that. Another concept is data portability, and that basically would allow a data subject to transfer his or her service to another provider. So the intent here is to not allow data subjects to be locked into a particular provider just because their data can't be ported. There's a lot more clarifications around controllers and processors. Unfortunately, I don't have time to get deeper in it right now, but there's a lot of controversy around the processors. Previously, the European data protection laws did not apply to processors. It applied to controllers. Controllers flowed down those legal obligations through things like model contracts. Under the new GDPR, processors themselves are directly liable and responsible under the laws. And so there are some real questions on how this will impact things like software as a service. This is an important area on the pseudonymization of personal data. And basically, this is the EU's response to big data. It understands that big data is important and is necessary for scientific, historical, and medical research. So they came up with this concept that if you can deaggregate the personal identifiers from the information and keep that identifier information separate from the other information, then it relaxes the standards on that pseudonymized personal data. And so if that data got hacked, then you wouldn't have to, for example, meet the breach notification requirements because there's no personal identifiers to bring it back to an individual. The codes of conduct I spoke briefly about, that's going to be an important area for you to evaluate whether or not you can leverage codes of conduct to simplify and streamline your compliance programs. The last point I wanted to make here is that the law provides for substantial penalties for failure to comply. So there's 2 tiers of fines. The first tier is 10 million euros or 2% of global revenues. If there's repeat offenses or gross offenses, then it goes to 20 million or 4% of global revenue. So that's a very significant risk. I just want to touch briefly on some other developments happening very quickly on Brexit. As long as the EU, as long as the UK is in the EU, it will remain to be bound by GDPR. Once it leaves the EU, then it will need to pass its own legislation similar to the Privacy Shield to say what it will do about the protection of European data. There's some other developments going on as well, such as the update to the EU Cookie Directive and the APAC privacy framework that was put in place in 2005. There's an update expected this fall.